They also supplement their position, you know, with certain views. They may look at someone's position, and she criticizes that. They may look at other factors, kind of to fill in the gaps. As someone that I think the professor mentioned joint criminal enterprise, my favorite topic, they may, if that's on the indictment or it gets slid in sometime on an amendment, they'll put in, just convict everybody, the joint criminal enterprise. And she talks about a pro-conviction basis. So I think that that's important. Let me just say some quick things about what is to be done. I have a paper, and I won't repeat it because I'm sure you can read it and go through it, on Rule 68. Rule 68 is a rule about exculpatory disclosure. And in all of our cases, this has been a big problem. There's a similar rule in most jurisdictions. There's a rule in the ICC on exculpatory disclosure. It's actually listed under one of the rights of the accused. In the prosecution, the ICC has to investigate both inculpatory and exculpatory material as part of his or her investigation. Whether it happens or not, we don't know, but that's the rule, and has to disclose it. This rule is particularly important for those who've been convicted and serving their sentence, because with the witnesses recanting, witnesses in exile have now changed their stories sometimes. The prosecution finds new Rule 68 material, as they did in the Military II case in which I am, after there are judgments, and they disclose thousands of pages late to everybody in the team during the trial, etc., when you can't use it. All of that goes on, and I've written about that. But the bottom line is that material still keeps coming. And in the future, it may be one of, and I don't know, it depends on what it is, but it may be a basis for a request to review. But I think what we have to do, because the policy of concealment, conscious or not, is an objective policy, is so prevalent, we have to start demanding, both as lawyers, but others who are community members and interested in justice and fairness, have to start demanding that the residual mechanism forces the prosecution on a system-wide basis to disclose the exculpatory material which has been in its files sometimes since 1994. So I think this is important because we all get, I think Philippe Larochelle talked about, it's this accidental discovery. You find it, we don't think you're looking for something else. You hear it from somebody else, it's ridiculous. But it's a rule, and it's a rule that we have to fight for to make it work for our clients. It's what we can do in a context of international injustice globally. It's what we can do to fight for the rights of our clients and the rights of the rights of everybody, right? But the rights of our clients, and for justice within the tribunals and within the limits in which we work. I mean, that's our job, and that's what we have to do. And I think that that's what we all have to, at some level, address, how to make what exists or what the structures are, whether you're talking about these tribunals or the never-ending battle with the P5, the Security Council Permanent 5 members, right, at the UN, any of these places, it's always a struggle to make them more accountable and to make these institutions not even democratic, but equal. We don't have the defense. There is no fairness to the defense. There is no equality in the application of the law. That's what we're talking about, and this is the venue in which we work.
Merci beaucoup.
De rien, mon plaisir.